Thank you. I don't think we have a whole lot of agenda items formally in place, if I'm correct. I did get your email to both Judge Garrett and I, Stephen, I think yesterday, and we were talking about setting up a Zoom call with Damani, and I'm open to that. I think that's our next step. I talked to Judge Garrett this morning about that. She was in agreement. I don't know if she responded to the email or not, but she's in agreement that that should be our next step, is just to go ahead and with the Zoom meeting.
That's great. I will contact Adam. Do you want me to contact Damani as well, or do you want to do that, Judge Freeman?
I can do that today. I know he had had some things come up in the last week or so, so we might want to shoot for about a week out. So
okay, can you hear me?
Yeah.
Sorry to interrupt. This is Judge Garrett. I just got here. I'm sorry. I'm on the phone and I've been having technical problems, but I'm connected now. So hi, everybody.
Welcome back.
Thanks. Sorry to interrupt your discussion. Please continue.
No, Stephen and I were just discussing next steps as far as setting up a Zoom meeting. We had talked about that this morning, Judge Garrett, and I think both of us agreed that maybe about a week and a half out for Damani.
That sounds good.
Judge Freeman and Judge Garrett, maybe the most efficient way to do this would be to have Jill contact all of us. And I think Judge Freeman, maybe you should set out a couple of days or times that you might be available. I suspect you're the most constricted time-wise. And then Jill can try to coordinate a common availability for us.
Okay.
Is this going to be an official work group public meeting, or is this a few of you getting together?
It's a few of us getting together. It's
Okay.
an informal conversation.
Okay.
Yeah.
And you're thinking about a meeting in about a week and a half?
Yeah, that first week in November should be perfect because I do have the criminal rotation that week, so I should be able to carve out more time and know my schedule a little bit better that week.
Okay.
And Jill, just in general, the purpose is to sort of recap what our process is with reviewing public safety assessment data once Dr. Peterson starts feeding that in, and to describe the role and the assistance we would be looking for from these two community members in evaluating that data, especially along the lines of racial disproportionality concerns, just so they're clear on what we'd be asking of them.
Yes, we'd ask for their perspective. We're not expecting them to be statistical experts, but we need the perspective of community people who, you know, have some different perspectives than we do on impacts of seemingly neutral policies on people of color and others. Does that make sense?
Yes.
Okay, good. But this would be an informal discussion simply because we're wanting to talk with them informally about our committee, what we do, give them an idea of what their participation would be, which is basically the same participation as any other member, you know, staying involved and giving perspectives. That's what we want from them, nothing different from anybody else. It's their, that's the role that they would play. So I think an informal conversation about our work group and what we're doing is appropriate.
All right, so we'll schedule that for a week and a half out. The only other item that we were going to touch on were the numbers from Dr. Peterson, but based on an email, I was looking for it now that we all got, I think, earlier this week. I don't anticipate we're going to get much of an update from Dr. Peterson today.
No, he was pretty clear about that in his email.
Yeah.
I think we can table that question until the next meeting when hopefully he'll have more information. But Bruce did have some information to give us.
Yes.
you may have talked about that before I joined the meeting.
No,
But,
we were waiting for you, Judge Garrett, for
oh,
that
good. Thank you.
piece, yeah.
Okay. And is Bruce with us?
I
Bruce
am.
is-
Oh,
Good. Hi, Bruce.
hi.
You know, I read your email. I liked your pretrial order form. It, you know, puts it all down and puts it in appropriate sections, and it looks like a good order form. Are you using that in your court now?
Yes. Yeah.
Uh-huh.
Yeah.
Good. Okay. Well, I'm looking forward to hearing from you about
Good.
these things and about pretrial services.
Yeah.
Is that next on our agenda? Should we go to that? Stephen, I don't mean to take that over. Stephen?
No, yeah, I was muted. I'm sorry. No, I think that's where Judge Freeman was headed also.
Okay, good. I don't want to just, you know, come blasting into the meeting and interrupt. So just want to be sure I'm not doing that. Okay, so then we're ready to hear from Bruce.
All righty. So we have a little information to share. We sent out the pretrial order to everybody, and thank you, Jill, for doing that yesterday. And that's, as I stated a minute ago, that's an order that is currently in use in district court. And I believe a variation of that is in use also with the municipal courts as well. And I think Jake might be able to speak to that specifically. But we've got our presentation sort of broken up into two parts. I was kind of going to do a bit of an overview for what's going on with the pretrial monitoring in district court. And then Jake was going to do the second half, which is talking about and sharing some details about how it actually all works, and a bit more of the just details of how it actually plays out, what we do, what we're able to do, and that kind of thing. So I'll go ahead and get started with mine. And I probably need to give a little disclaimer here that when I was zooming in on the last meeting, I was in the lounge at SeaTac Airport waiting for a flight to Hawaii. And so I can't say that I was 100% there. In fact, I had some connectivity issues and kind of cut out there for a few minutes during part of it, but I did go back and I re-listened to the tape of the meeting. And so I feel like I'm pretty up to speed with what happened at the last meeting. And one thing that I was struck with is that a lot of different topics came up at that meeting last month. There was a lot of different topics. And so one thing I wanted to start with is, and I know this seems obvious, but after I listened to that recording of the last, the audio video of the last meeting, I wasn't 100% sure it really was that obvious, but so I want to state the obvious, which is there's in terms of pretrial monitoring and victim safety issues that came up at the last meeting, we've got two possibilities. One is preventative and the other one is reactive. And preventative, in my mind, and there's probably somebody's got better words to be using for this, so I'll just tell you what I mean by this. So preventative is designed to keep something undesirable from occurring. And in the world of criminal justice, the only way I'm aware of to do that, to actually assure that something undesirable doesn't occur, is to incarcerate somebody. And everything aside from that is more reactive or responsive. That includes pretrial monitoring. It includes the electronic devices that are put on people, even if they can, it's all responding to something that has already happened. And so when it comes to victim safety, we tell people you need to be, vigilant in keeping an awareness of your surroundings. You need to be quick to call 911 if something does not look or feel right, or you suspect something. It's like a no contact order. It's a piece of paper. You need to be looking out for your own best interest. And a piece of paper doesn't actually stop something from happening. And so the model that we have in both pre and post is it's reactive. It's acting in response to a situation, rather than controlling it. And But that doesn't mean all is lost. That it's doesn't mean it's an ineffective system, but it does mean it's not like incarceration. It's not like having somebody actually in a jail or a prison to keep a victim or the community safe. So examples of the reactive nature would be if there's violations, alleged violations of the law, positive UA results, electronic device violations. We're responding to something that has allegedly already happened. And so the tools that we have available to us are, it fall into three categories, the way I see it. One is motivation, and it's encouraging defendants to comply with the pretrial order, encouraging them to access community resources that may be creating or may help them eliminate barriers to their compliance and their success. And this could be, housing. It could be, the whole, food, shelter kind of things. It might be their lack of transportation and trying to help people problem solve so that they can ultimately show up for their court hearings and their appointments as they are supposed to. Deterrence would be, you've got expectations that have been handed down by a judicial officer, making sure that the defendant is aware of the court-ordered conditions, making sure they know we're doing record checks with the state database, with the Department of Licensing. We do, if it's ordered, we do substance testing. So trying to find a combination of motivation and deterrence to get folks to comply with the pretrial order. And if everybody did, we would not have community and victim safety issues. The third part of that is a response that when an alleged violation takes place, that's where the pretrial services comes into play, and we can respond. And by that, I mean, we report the alleged violations to the court, and we schedule court hearings as appropriate, and then a judicial officer will evaluate the information they're presented with and make a decision as to what will happen next. And
Can I
so,
interrupt you with a question, Bruce?
sure.
You said that if there's a violation of pretrial conditions, that's when pretrial services comes into play. But isn't pretrial services involved before then in administering the other aspects of pretrial conditions that you were describing?
Yeah, and so I probably misstated, because I should have finished the sentence by saying, that's when pretrial services kicks in to
the court process?
To deal with alleged violations. We're already very involved in these cases.
Okay,
terms
good.
of-
I just wanted to be sure I had that right.
Yeah, no, that's what I meant is if motivation doesn't work and deterrence doesn't work, then if we've done everything we can do to motivate them, and we've done everything we can to deter them, and an alleged violation takes place, that's where it probably kicked in. Is probably the wrong.
That's when pretrial
Right.
services goes to court, really. So that's when the court sees pretrial services, right?
Yeah, that's a better way to say it. We're very involved from literally the day they're
Good.
placed on pretrial supervision. And
Okay,
those are some things that Jake will talk about in a minute or two here. But that's what I meant is when all else fails, an alleged violation takes place, that's when we start reporting things to the court. I mean,
okay.
we don't report good news to the court. We report alleged violations. And so thank you for asking that. I would not want that one being unclear. And so we can only monitor both what is in either the pretrial order or some other court document where a judicial officer specifically imposes conditions on a defendant. I understand or have heard that Department of Corrections may have the ability to add in conditions. We do not. So if we're providing substance testing or an electronic device is ordered, everything is because a judicial officer told us that that's an expectation of that defendant and that we are to be involved in making sure that they comply. And if they don't, the court wants to know about it. And so it includes and it's limited to what the court orders. So we aren't able to just throw random conditions on a defendant. And I know other parts of the system, and I don't know how it works with the pretrial unit in Superior Court, but that's our world down here in the misdemeanor level. And so actually, I think that kind of is a quick summary of what I was going to say. And then Jake's got some more details about the actual unit itself in district court and some of the process and procedures that we have. Were there any questions about any of the comments I've made that that folks have comments or questions?
You answered mine. Thanks.
Yeah, thank you. All right. Well, Jake, you want to go ahead and
Sure. Yeah, thank you, Bruce. Yeah, so I'll talk a little bit about what happens when the case basically arrives at district court probation. The client shows up right after court or upon release from custody and comes into our office, sets everything up with the front desk, and then actually we'll meet with a probation officer right then and there before they leave. So they get everything set up, get all their appointments scheduled, and the probation officer comes out, reviews the pretrial order with them, and makes clear all the expectations that that specific order has before they leave, and answer any questions they might have, and point out court dates at that point, their next court date, and verify that they know when all their appointments would be. They're then seen for their intake within 10 business days, or they are, if it's a domestic violence charge, it would be within 5 business days. At that intake appointment, we review brief social conditions or background, legal history, and conduct a pretrial assessment, risk assessment, which currently we're using at this point ASRA. And that determines the frequency of how often they would report to our office, and that could range from once a week to once a month. As far as ongoing appointments, those are done with our probation officers face-to-face. They're done Zoom. They're also done telephonically, and our probation officers go out to they do go out to all the municipalities we have contracts with for those court dates, and can be seen at those court dates as well. Let's see. So for each pretrial case, there's basically kind of a general set of conditions that relate to all of them. And right now, I believe I ran a report yesterday. We have roughly about 380 pretrial referrals that we're currently monitoring in our office. And for each of those, generally speaking, criminal background checks and DOL checks are run at each appointment to make sure there's no more criminal behavior. And we review all the court dates that they might have in the near future with them and remind them of what's coming up. Many or often referrals to community resources come up, and as needed, we will direct them to those the best we can. Again, those are as needed. Very often it's a housing issue, jobs issue, transportation. We can provide bus passes. We get bus passes every year that we hand out. So we do our best with those. And then the judge can also order, like Bruce mentioned, when they order specific conditions, we monitor those. And some of those can be substance testing. We do UAs, we do oral swabs, which are instant tests, and we can do PBTs, so portable breath tests. We can facilitate, like was mentioned, the electronic devices, making sure they get installed, and then reporting any of those violations and acting upon those for the court. So that involves both friendship services for the small town or for the municipal courts, as well as for the county with the alternatives. We often facilitate for DUI cases, specifically the installation of ignition interlock, and make those referrals for make sure that happens within a 5-day period. We can often, well, not very often, but sometimes we have to have the clients surrender license plates, typically on DUI cases where there's refusal to stop driving, or we can place go to their place and place a club on their vehicle. I actually have one today. Those don't happen too often, but they can come up. We also verify that weapons on DV case have been surrendered, and if they haven't immediately been surrendered, we can provide instruction on how to do so with their jurisdiction that they're coming from. And we also review and make clear what their no contact orders are, and we review those as well in JABS to make sure they're active or not, or the status of those. We can update the clients. As far as text messages, I know Bruce has talked about this at previous meetings, but we send text messages for all district court cases for Thursday afternoon calendars and Friday probation hearings, as well as all municipal courts and many superior court hearings. I believe over the pandemic, we've done, Bruce, correct me if I'm wrong, but about 4,800 texts, I believe we've sent for court hearings for the superior court. Texts are sent to defendants regardless of if they're on pretrial supervision or not. if they're on the calendar, we have our number, we will send it to them. As well as district court has a phone call reminder system that they use for omnibus and for arraignment calendars. So those are some of the functions that district court does for supervision. Does that leave anything out or any questions that could help?
I can't think of anything you left out. Thank you.
Yes, thank you. I don't have any questions, but thank you. That was a good summary.
I do have a question, Jake.
Sure.
Assuming it isn't a substance, there's no substance testing, you indicated that it could be a week to a month reporting. How often are you running criminal histories to see if there's been
Sure.
recent criminal activity?
For the appointment, at the appointment, right beforehand, usually when we know they're on hold, they're calling, or then lobby, we'll run it real quick. And then when we meet with them, we'll have it ready. And if there is something, we can, bring that up. But if there's not, we'll make a note of this clear.
Got it. Thank you.
You bet.
Jake or Bruce, can you estimate the percentage of cases you're overseeing that you report back to the court on non-compliance?
Ooh. For pretrial specifically? Or
Yeah.
I don't have a number
Hmm.
offhand. That's a good question.
Ballpark? I mean, many, very, very few?
I wouldn't say very few. It wouldn't be majority, I wouldn't think. But somewhere underneath 50%. Yeah. I could look that up. I don't have it off the top of my head. I apologize. I don't have the computer in front of me.
Oh, that's okay. But yes, if you could get back to us with that, that would be good.
Okay.
And I do have a question.
Sure.
And the question is, you said that when you assess defendants, you use the OSRA as the tool, which is, I know that district court has used the OSRA in the past. Have you considered using other tools, including the public risk assessment tool that the Superior Court's been looking at?
Yes, absolutely. It's something we're currently looking at updating. For post-conviction cases, we use the ORAS, so a different risk assessment there. But I actually spoke just the other day with Alan up in Pretrial Services about that. And Bruce and I will be addressing it here shortly, I guess.
Good. Yeah, I have my doubts about the OSRA on a pretrial basis, just because it's my understanding that that was not the intent when it was drawn up. Judge Snyder felt that it was, based on his conversations with some of the people that were involved. But I talked with other people who said, no, it's for post-conviction. But, obviously I'm not telling your court how you're going to do your work, but I think the public risk assessment is good, especially as fine-tuned by our work group. Bruce, you and Jake might want to just talk about that and see where you end up.
Yeah, I think I got it from you, Jake, the actual scoring tool from one of the pretrial services officers in Superior Court. I think we've taken a look at that. I think, and so honestly, our next step is we'll need to take a closer look at it, make sure it's something that we would recommend to the judges, and then take it to the district court judges who will make a final decision as to whether that's the tool they want us using or not. But yeah, that's definitely something we've looked at and we'll continue to look at as well. Yeah.
Okay, I'm just thinking that as we go through this process and work together, it's nice to envision Superior Court and District Court working together on these services as much as possible. And if both courts were using similar or the same risk assessment tools, it seems like that would be a step in that direction.
That actually brings up a question for me, just because I'm a little less familiar with the use in practice. And if I remember correctly, it does take some, for district court, oftentimes the PO is filling this out morning of and calculating it by hand at the hearing. Is that?
For district court or for Superior Court?
Well, I'm thinking municipal courts in general. I know district court, you have until 1:30 for first appearances, but oftentimes
Right.
with those morning calendars, you've got the PO down there calculating the risk assessment,
Okay.
even in the courtroom. Is that right?
That was actually a bail study review. I think what maybe you're thinking of, we were
Okay.
doing for the city of Bellingham for a friendship services screening. So
Okay.
that was a little bit different. That was not a risk assessment we were doing for supervision. That was just kind of a courtesy we were doing for the city of Bellingham.
Got it. So that was something developed
Yeah.
through friendship diversion and the city.
Yes, exactly. That we
Okay.
are assisting with. Yep, on those pre-trial cases. Yeah.
Thank you.
John, excuse me, John from pretrial is doing the PSA every morning and sending it out to all involved parties ahead of time. One question I have for Bruce and Jake, and thanks for your presentation. There's been a lot of questions in the past about law enforcement's ability to respond to any violations on electronic home monitoring in real time. Has that been your experience?
I would say, majority of the devices we have used are the SCRAM or the FD or the TAD, so the alcohol monitoring. So with those, when we do get a violation, those are reported to the court. And we get them on the next available court date. The GPS are not as used as often, and when they are, it is not an immediate response or an immediate arrest at the time. So we would be reporting those when we get them as well to the court.
Okay, thank you. That's helpful.
Yeah.
I think there's perception sometimes that, somebody violates and a SWAT team comes out.
Right.
In these cases, which certainly not the experience I've had. We also had an issue just in juvenile this last week where a young man was on a GPS monitor, and we contract with WASPIC for that. And actually the bracelet came off, and there was no alarm that went off regarding the bracelet. So the kid was, terrified. So we actually put the bracelet in his backpack so he could track him going to and from school and stuff. But we wouldn't have known that the bracelet had even come off, and he could have been out doing whatever in the meantime if he's left his backpack at home, and we would have had no clue. So those things aren't foolproof.
So I was going to add a couple points, and if this is too much information, just somebody cut me off. But on the electronic equipment program that is coordinated through probation using the sheriff's office, alternative correction center as our partner with the devices. So for that program, that is used, let me tell you what, it's not used for sentencing purposes. That would go through the sheriff's office, EHM, EHD program, what used to be called, I think, work release, or what used to be called parks program, those kinds of things. With our program for the electronic devices is used for pretrial, or generally the other option would be post-conviction probation sanctions handed down by the court. And so the sheriff, so that's where we are completely on a responsive level to when alleged violations take place. The sheriff's office, under that set of circumstances, does not have the ability or the authority, and I want to be really careful, I don't want to speak for the sheriff's office, but to go out and respond to those alleged violations. And so that's when the reports come into probation, and then we would then process them appropriately into the courtroom and whatnot. And also on the electronic program that we have with the circumstances, the pre and post I just described, the funding is such that there is no cost to the defendant, because that was a real barrier. That was the biggest barrier to the judges being able to use these devices, is that the defendants simply could not afford it, and they can become very pricey over time, depending on how long someone is on the device. So the funding we have pays the entire cost of the device, the lease on the device. We don't charge any administrative overhead. I don't believe the sheriff's office does either. But there's a difference between our electronic program and how it's used and the other programs used by the sheriffs through their work center.
I would like to chime in and Jake can correct me here because I'm going back a couple of years. But this is something that Carol brought up last time, and I wish we had either Carol or Darlene from the city on this, but they do use friendship diversion services oftentimes for their electronic monitoring services through pretrial as well, as my understanding. And I do know the municipalities that for both, restricting an individual's movement to a home or work, but also prohibiting them from certain areas. And to kind of jump off of what Dave said, typically that's not going to go to law enforcement if there's a violation. It will come, and Friendship is very timely with getting violations over. In fact, they do it almost immediately from what I've seen. But oftentimes it'll come in the morning. A judge will review that first thing in the morning and make a decision to either note it up for a review hearing, or at times, and if the circumstances are appropriate, like if it is a DV situation and they were prohibited from a certain area, issue a bench warrant at that point for the violation. So that's my understanding. Jake can correct me if I'm wrong on that protocol, but.
Yeah, and typically on those DV cases, when that GPS is ordered, it is set like a parameter, 1,000 feet around, and typically it gives it a bigger parameter than the actual no contact order, so it's kind of that warning zone. Yeah. And when that does go off, and I believe in Friendship Services is open, they will also, they shoot us a notice of violate or their violation, then we inform the court. They also notify dispatch, and we'll document that as well. And then in some circumstances, the judge on the pretrial order may say, if any violation, potentially issue a warrant. And so at some point, that can occur as well. That's obviously up to the judicial officer at that point, but that's another response that can be taken. Thanks.
I'd like to go back to Judge Garrett's point about the choice of the risk assessment instrument for pretrial release. And it might be useful to revisit the historical arc of these conversations and just make sure we're still all on the same page. From the outset, the goal of this work group was looking at implementation of a risk assessment tool that all the courts across Whatcom County jurisdictions could utilize, because we felt that with multiple charges and multiple venues, uniformity would be a goal to shoot for. At the same time, the most urgent need and the jurisdiction that we had most traction in was Superior Court, because there weren't release alternatives. So we targeted the work first on Superior Court. But I think we had informal agreement, and Bruce, tell me if I'm misstating this, but I think you were amongst that from other court systems, that if the instrument we tested in Superior Court seemed effective, that would put a thumb on the scale toward some common adoption. So first of all, I think that's accurate. Judge Garrett, correct me if you don't think it is. But so
No, that's my memory also. Sorry, I was on mute, but yeah, that's my memory too.
Okay, so I welcome Bruce and Jake talking about ASR versus the PSA or anything else. And certainly early adoption is great, but I also think that one of the pieces in that expansion process would be having Dr. Peterson and hopefully Damani Johnson and Adam Fryer help us assess post-implementation data to make sure that it's effective. And on the basis of that information, that might be a decision point where we would ask other courts to look a little more aggressively at making a switch there.
Is Dr. Peterson still available? I know Dave Reynolds, you and I were both compiling data, and then I know, and then forwarding it to Dr. Peterson. And I can just tell you what happened with ours. The pandemic hit, and due to resources and staffing, we just could not, it was a time-consuming task. We just could not continue that. So is that still in process in terms of evaluating all that data and determining and sort of doing a local validation of the PSA, or where does anybody shed any light on that particular topic?
I can tell you where I think we are, and then perhaps Judge Freeman can update us on current practices. But in the beginning of the COVID shutdown, the Supreme Court ordered that all superior courts release all defendants except those who pose a substantial public risk. So the element in the rule of likelihood to show up for trial was more or less suspended. And we released, a lot of people, like at least half the defendants who had cases pending in the Superior Court. And I don't know the current status of the Supreme Court's order or of the current status of Superior Court detentions, but I suspect they continue to be down, and I suspect Judge Freeman can give us more information about that.
Yeah, I could pull up the Monday report here in a moment, but there are still booking restrictions in place. I'm sure district court's aware of that. So we're just not seeing as many booked either. So that's certainly been a factor. And then when it comes to release, I would say that still is in play to some extent. It's lifted a bit since Judge Garrett was on the bench, but I would still say we are restricted on what we're booking and who we're holding. So, and I have brought that up at a couple prior meetings as well, because I do question what that is going to do to the numbers and the analysis. That and the major change that we had that kind of mirrored what case law did, I think, in district court about failures to appear, and the fact that we are not issuing bench warrants for failures to appear at status now, and those are being set over to trial dates. So I think that's going to also play an impact on appearance history as well. And I'm not sure how we're going to tease that out of the numbers, but.
I think this would be a good conversation to have when we have Dr. Peterson back with us, probably next meeting. And again, just historically, Bruce, I think you'll recall, there were two pieces that Dr. Peterson was helping, two at least analytically. One was he was looking at data you and Dave were providing him. He was scoring historical cases by the PSA criteria to see if the predictive value of those fit with our defendant population. And that was a factor in whether or not that was a good thing for us to adopt. And I think the answer to that was yes, he found it adequately predictive. The second phase that we wanted to use him for, and I think he may be trying to get traction on now, is whether now that we are using it for release decisions, is it actually continuing to show an adequate effective rate in predicting failures to appear or no new crimes. And I'm not sure that we're anywhere close enough to normal operations in using the PSA to make release decisions without the interference of all these other factors for him to be able to make that analysis for us. But at some point he will be, and that'll be a periodic validation of what it looks like in real life. And I think that was the point I was talking about, where we hoped other courts would see enough justification in actuality to join the Superior Court in use of the PSA.
Thank you. That's a good update. And I do agree that there is a lot of value a lot of value in using a common tool if in fact it can work that way. I do see a lot of value in that.
Well, that's a topic for another day when Dr. Peterson has joined us, and he can give us some insights then. The insights that we thought we were going to get a year or two in have been disrupted by the pandemic. So we'll just do the best we can. And you know what, with that, I have to go. I have another meeting that I've got to get into. When shall we meet again?
We have the next meeting scheduled for December 7th.
Okay, why don't we keep that on the calendar for now? Line up our ducks for that meeting. We can cancel it if it's simply no, if we don't need to do it, but I think we should be able to get some information from Dr. Peterson by then, and Stephen and Dave and I can report back about our conversations with Adam and Damani. And so let's plan for that meeting. Does that sound good?
Yeah, should we then hold off on setting our 2022 schedule until then, or that's something we want to talk about today?
Well, you're the one with the complicated schedule. So why don't you decide? I can be pretty flexible. So it's just a question of frequency. Why don't we plan, I don't know, a February meeting and an April meeting, at least for starters, and that'll help us assess where we are. What do you think?
Sounds like a good plan to me.
And
Okay.
I'll just put on the recording my earlier email request that we think of a date other than the third Tuesday, which I have a continuing conflict with.
Oh, okay. Well, maybe we should just talk about that now. I can say pretty definitively that pretty much any day works for me. Tuesday least of all. So I guess I'm with you, Stephen. I can be flexible around whatever the group schedules. I'm going to sign off now, but just know that whatever times you come up with, I'll be able to do it. Okay?
Great.
Great. Okay. Thank you all. Bye now.
So
Bye.
Jill, maybe you could get Judge Freeman's information and check with Bruce and Jake and John and Maya, the people who have other commitments all over their calendars for common times that would be available.
I think since we're all here, this might be the most efficient if we have a few minutes to talk about it. If noon on Tuesdays is difficult for everyone, I'm wondering if there's another day of the week that works better.
I think that for me, and I don't want to speak for Jake's schedule, but for me, I think that actually Tuesday at noon does work fine, and pretty much any other day of the week works great. Monday is not our best day of the week for adding one more thing, to be honest with you. So, and then Jake, I'll let you speak to if you got something to add there as well. So.
No, I think Friday mornings would not work with court, and Thursday afternoons are pretty tricky, but other than that, we can make it work.
How about Wednesdays? Maya, how does your Wednesdays look?
I was just looking, there's lead, but that's not till 3:30 on Wednesdays, every other Wednesday.
The only thing that both of us have is, I think, our quarterly criminal bar roundtable falls on Wednesdays, don't they?
They do, it's the second, is it this, I don't have one in, I guess an invite didn't go out for the next one because we just had one in
It's second Wednesday.
second Wednesday.
And that's quarterly, so we could avoid those months.
Are we still
We
talking
do a
about the lunch
Wednesday.
hour?
Yeah, if we do after 11 would be preferred. We have often a staff meeting Wednesday morning, but
So you could do it at 11 on Wednesdays?
from 11 on would work. Yep.
I'd love to not have another lunch meeting. It's not cool, really.
The only issue with that is it will be hit and miss as far as my availability. Because if I'm in trial or if I'm,
Unless we did a Friday, but Fridays are always.
Welcome, Dr. Peterson. We're down to scheduling next year's meetings.
Thank you for having me. I apologize for being late.
Well, why don't we stick with what, 12 or 12:30 on a Wednesday in February and one in April?
Yep.
yeah,
And you'll let me know if that conflicts with your quarterly meeting that you were talking about, Judge Freeman?
Yeah, I can
Okay.
let you know.
We're keeping our Tuesday in December, is that right? We're gonna still go with the 7th, not move it to a Wednesday?
We can move it if that's what the group would like to do. Dr. Peterson, how are you for meeting on Wednesdays instead of Tuesdays?
It would depend on the Wednesday. And there's actually another pretrial group for a different county that I'm working on, but it's only one Wednesday a month. So odds are, 3 out of 4 times that'll be good.
Okay, well, I will work on getting maybe the December meeting rescheduled to a Wednesday and then scheduling February and April 2022. Dr. Peterson, if you have a few minutes to stay after the meeting just to check our calendar so I don't schedule on top of your existing meetings, that would be great.
Yes, of course. Thank you.
Thank you.
So I think between now, I'm not sure if we're going to be able to get really how far between now and the December meeting, but probably within one of the first meetings in 2022, Jake and I will have had time to do a lot more work on looking at the PSA. And we don't need to go through now. I got all kinds of questions about the experience that Superior Court has had and just learning more about it specifically. I mean, I know a lot of the basics of it, but I think that's something that we can be taking a look at and get back to the group at some point in one of the next few meetings. And let you know our progress on that.
Thank you, Bruce. Have we covered the agenda?
I think we have.
Judge Freeman, do you want to do the honors of adjourning or?
Yeah, I think with that we can adjourn.
Okay,